Well, I see it's now 8:15, which is our start time. So just a few remarks before I turn it over to George, who is going to preside. I'm Glenn Hendricks, one of the co-chairs of the conference. Welcome, everyone. We're delighted that you've joined us for the 12th annual ABA RAA conference on the resolution of CIS-related disputes. First one we've ever done online. Hopefully next year we'll be back in Moscow. One of the advantages of doing it online is we get to feature some of what's become the new normal. And part of the new normal is doing cross-examinations over video, as you'll see here in this coming session. We have presiding George Berman. I'll introduce George, who will introduce the other participants. George is a professor at Columbia University in New York. He's the chief reporter for the American Law Institute's restatement project on the law of U.S. law of international arbitration. If you're not a U.S. lawyer, you may not understand or appreciate the significance of that. For American lawyers, it is a hugely big deal. If our common law system just summarizing what the law is, and in some cases kind of even shaping it. It's a resource for judges, and it's really a monumental project and an incredibly useful one for practitioners and the judiciary. George is also a very active arbitrator and appears on really most every list I've seen of the top international arbitrators in the world. So we're really delighted that he could join us here today. This session is recorded, so you can watch it later on YouTube. Unlike the coffee shop sessions that many of you have been participating in, this one is not interactive. So the audience participation will be by watching, and perhaps at the end some questions by chat. But I don't know that we'll be able to get everyone to answer everything, so we may have to follow up individually. So with that, I'm going to turn it over to George, who will get us started here.
Well, thank you, Glenn. It's a pleasure and an honor to play this role. I wish we were in Moscow, maybe another time. I want to wish everybody a good morning, afternoon, or evening, as the case may be. I want to welcome you to a particular segment of the hearings in the case of LearnFast UK Limited versus Republic of Kalia, and in particular, our examination of expert witnesses. Now, a lot has happened in this case. We obviously came a long way since the case management conference held yesterday. In that interval, we have, of course, had proceedings on issues of merits. And if there were any jurisdictional objections, we would have entertained them by now as well. So we are fast forwarding, extremely fast forwarding to the quantum stage, liability having been imposed upon the respondent. I'm sitting as a sole arbitrator with a case of this magnitude and complexity. It would have been perhaps preferable to have a panel of three. I think we would have had a panel of three, but we are simplifying things, as I'm sure you're appreciating. As Glenn mentioned, we are recorded. That's rather bad news for our participants because they are going to deliberately fail to meet the standards that they ordinarily aspire to meet. And that will be recorded for all time and always associated with them and their respective capabilities. They may want to see to it that this recording is at some point deleted, lest it reflect on their reputations. Now, this proceeding, as I indicated, was essentially bifurcated. We're in the damages phase. Now, our participants are all deeply seasoned participants in the roles in which they are playing, and in some cases, other roles. Now we're going to hear from the following, and our participants therefore are Richard Samuel, who will represent the respondent in this case. He will begin. The assumption is that we have all received the expert reports and that there either was no direct or it was minimal, which is the state of the art. The expert to be cross-examined is Vladimir Nevedev, the expert for claimant. We will then have claimant's counsel, Lisa Richman, who will perform cross-examination, and the expert to be cross-examined is Laura Hardin. I'll say a word about all four in a moment. We are only having cross-examination today. We might have, in reality, have had redirect. We might have had recross. We might have had all kinds of shenanigans like extended hot tubbing that I assume you're familiar with. As Glenn mentioned, because we have only 1 hour and so much to accomplish, regrettably, there really won't be time for questions. And we didn't want to put you to the task of formulating questions and giving them to us only to find out that we had no time to address those questions. So our apologies, but I think you'll appreciate we need all the time we have. Now, I've asked my participants to allow me to say only a word or two about them for lack of time to do more, though much more could be said. Richard Samuel, respondent counsel, is a barrister in the Temple in London. He is working principally in English law, doing so principally in English courts, but in international arbitrations around the world. Claimant's counsel, Lisa Richman, is a partner and managing director of McDermott, Will, and Emery in Houston, Texas. She performs all manner of international dispute resolution, litigation, mediation, and arbitration. And she is concerned often with public international law issues, which will not always be the case in our commercial arbitration cases. Turning to our experts. Expert for claimant, who will be cross-examined by Richard, is Vladimir Nevedev, and he is a partner in the Moscow office of PwC, formerly known as PricewaterhouseCoopers, and he is, as I say, in their forensic practice and participating in proceedings involved with the laws, principally of jurisdictions in Central and Eastern Europe. He's appeared as an expert in countless cases before all leading institutions. And of course, we have yet one more expert, and that is Laura Hardin, who is managing director in the Houston office of Alvarez and Marsal. She is a seasoned damages expert. And fortunately, in a case such as this, a fluent Russian speaker. But she will not display those skills today, I trust. Now, because we're in the damages phase, it isn't as necessary as it would be if we were in the liability phase for you to know all the details of this case. Some of you may not have attended the case management conference that was held yesterday. I think we would lose some color if nothing was said about the dispute. And in fact, aspects of the dispute necessarily surface in the damages phase. So, in very, very brief compass. This is a case, and of course I want to remind you that we're sitting in London and we're performing under the UNCITRAL rules of commercial arbitration. Now, this case involves a claim by LearnFast UK, which is an enterprise focused on the development and management of international learning centers. LearnFast UK has the ambition of developing a practice outside of the UK and Western Europe, and is venturing into the state of Kalia with a view toward developing an international learning center. One of the hallmarks of LearnFast is that it aspires to produce a learning environment that is more diverse, that is more international than would ordinarily be the case in otherwise comparable local schools. And that turns out to be very important in this case. One of the advantages of doing that, of producing an enterprise that functions differently, is that it would not enter into as direct competition with the local schools as it otherwise would. Fortunately for LearnFast, it, upon request, received a license from Kalia to make the investment that it has made. I should say that its ambitions are not limited to establishing a learning center in Kalia, but establishing an entire network of learning centers, about which we may hear more. That was the fortunate part. Unfortunate for claimant is that they are then issued a circular by the government of Kalia, which required that the learning center operate in the same manner as local schools, thereby, according to claimant, depriving claimant of what would have been its market advantage and what would have justified the investment that it has made. It has fallen in hard times and has only been sustaining losses rather than profits. It has claimed, because it has prevailed, that the circular and other unexpected administrative measures have essentially undermined their legitimate expectations, and as a result of which suffered the monetary loss that it has. I don't think I need to say more about that. Respondent has had a number of objections to the claim. Among them, questioning whether the investment was made, whether an investment was made, and whether it was made in this project. Questioning whether, and this will be important in what follows, questioning whether their reliance on financial statements that they have is unjustified, and that they have ultimately failed to reduce the proof, that the value of this enterprise was from the start overestimated by LearnFast UK, and finally, that there was in fact no agreement that any network would be established. We're going to have to leave it to that. I think that's more than sufficient. We are going to proceed with the remaining time, each side enjoying 15 minutes or thereabouts, but not very different than 15 minutes. I implore you all. We will follow with a commentary. I will play some role in that, but all four of our protagonists will also comment on what they have just participated in and experienced, because they will be able to tell us what their particular challenges were, how they might have done something differently under other circumstances. Before we get started, I have been asked, and it's my pleasure to acknowledge the services to us of the ICDR, International Center for Dispute Resolution in the US, and PwC, of which Vladimir is, of course, a member, for inspiring the case that we are dealing with. And it must be said that we owe a great deal to Glenn Hendricks. who introduced me. Glenn is managing partner in Atlanta in the law firm of Arnall, Golden, Gregory, LLP. And were it not for him, this project would not have been conceived and not have been orchestrated as well as it has. Now, I think it's time to begin. And so we're going to begin on the assumption that the expert reports were available to everybody, that there either was no direct examination or minimal direct examination, and we'll proceed instantly with cross-examination of Vladimir Nevedev by Richard Samuel. Richard, would you take it from here?
Thank you very much, George. Because I'm going first, we and the audience includes a lot of civil code lawyers to whom cross-examination won't be first nature. We agreed that I'd restate some of the basics of the common law approach, is that we separate establishing fact and arguing about the facts. We argue facts through the submissions at either end of the process, at the opening and closing, and in the middle, in this bit in the middle, we try to establish fact through cross-examination. I'm not going to be arguing about the facts or the interpretation of them with witnesses of fact, because their opinion is irrelevant. Where we're dealing with experts, that's the exception to the rule. Their opinion is there to assist the tribunal, and cross-examination is my chance to challenge his opinion. So let's try to challenge Mr. Smith's opinion. Mr. Smith, admit it. We all know you're only giving this opinion because your client has paid you to.
Actually, no. I take my role as an expert extremely seriously, and my reputation is very important to me. So as I stated in my report on page 26, as you could see, I stated very clearly that I acknowledge and I confirm that my duty to the tribunal overrides my duty to my client. And that the opinion expressed in the report is my own.
Oh dear. To undermine Mr. Smith's opinion, I'm going to have to think harder and I'm going to have to work harder. So what makes up an expert opinion? 5 elements: facts, assumptions, methodology, conclusions, and relevant expertise. It's the function of cross-examination to attack those 5 elements. It's the function of argument afterwards to use the work of cross-examination to give reasons to the tribunal to reject the opinion as unreliable. So in cross-examination, I want to establish certain propositions with the expert, that he's either made errors of fact, unsafe assumptions are in the report, flawed methodology is in it, or he's reached unreasonable conclusions, or he lacks expertise. Let's try that with a methodology. Mr. Smith, your approach to valuing LearnFast UK's loss of investment in the Caton City project in the subsidiary Calia has been to look at Calia's audited accounts for 2005, the last set before it went into liquidation. But why do you think that's the right approach?
As you pointed out very correctly to 2005 accounts, this set of accounts was the latest set of accounts available for me before the company went into the bankruptcy procedures. And obviously, taking into account that your client hasn't shared detailed financial information of the company, which was available for them, but it wasn't provided to me for the analysis. This was the only reliable source of information. In particular, it was audited as well.
Oh dear. I asked why. Mr. Smith told me. I gave Mr. Smith control and he took it. I asked an open question and I need to ask closed questions. So I need to put a series of propositions to him to agree or disagree with and try and get as much agreement as possible. Let's try. We'll take 3 propositions and try and establish those with him for establish reasons for later to argue about. At the first one, let's try and establish a proposition of fact. The proposition I'm going to try and establish is that there were other means available for Mr. Smith to establish the value of the parent's investment in the Caton City project. I can then argue in closing submissions that would have been better. Let's give it a go. Mr. Smith, page 10 of your report. Could you go there?
Yes, it's in front of me.
Top of that page, you've got table 1.
Mhm.
That's an extract from the balance sheet of Kalia's accounts for 2005, isn't it?
Yes.
And at the bottom there, you have recorded invested capital of $1.2 million.
Yes.
Go down to page 11 in your report, please. And we see summary 1, second paragraph. And you've taken that $1.2 million investment as the value of the claim, the lost investment. Yes?
Yes.
You explain at page 9 why you've done that. If you just go there, paragraph 3.2, you explain there that Kalia's liquidators have not disclosed the financial information to you underlying the accounts. Yes?
Yes.
And as a result, you've had to rely on publicly available information. Correct?
Yes. Correct.
And then the conclusion you draw is at paragraph 3.3 just below, where you say that accordingly, this is the best basis for assessing the actual level of investment by the parent into the subsidiary for the Caton City project. Correct?
Correct.
You say that's the best basis of doing so. Available.
It is the best. Yes.
Yeah. And it's for that reason, going back to table 1, that you've taken that $1.2 million figure from the accounts, the 2005 accounts, and in particular, at the top of that table, the $780,000 directly in from Loanfast UK. Correct?
Correct.
But if Loanfast UK made that $780,000 investment, it should have records of it, shouldn't it?
Of course.
And those records would be in the form of bank statements, wouldn't they?
It is true. Yeah.
Payment orders?
Yeah. One of the books where it will be reflected. Yeah.
And one would expect loan agreements as well, wouldn't one?
Of course.
But there's no reference to any of those records in your report, is there?
Yes. But I have to say that the financial statements of Loanfast UK, which was also audited, contains, and it wasn't qualified, contains a particular record in relation to the loan issued towards Kalia City project.
There's no reference in your report to the underlying financial records of the parent company in relation to those loans of $780,000, is there?
Can you repeat this question, please?
There is no reference in your report to your having looked at the underlying data of the parent company for the year 2005, is there?
It is actually true. However, I have to say that financial statements itself, which I relied upon, is a summary, and it has basically, how to say, summary of transactions and summary of balances.
I understand that, Mr. Smith, but the parent company is your client, isn't it?
Yes, it's true.
If you'd asked for the records from your client, it would have given them to you, wouldn't it?
Yes.
And if you had done, you would have been in a better position to assess the loss.
It would be just additional evidence, I would say.
There we are. We've tried to establish a fact that the existence of this opportunity, which he didn't take. Let's take a second point, which is challenging a methodology. And we're sticking with table 1. We want to challenge the fact that table 1 fails to distinguish between the parent company's investment in Kalia and Mr. Peters' personal investment in the company. He is the shareholder of the company. For that reason, we can argue from there that the experts make a basic error, it means his conclusion on this point is wrong. It undermines his credibility, and it means his other conclusions are suspect. Let's try. Page 3 of your report, please, Mr. Smith.
Page 3?
Page 3.
Yep.
You explained there a little bit about your experience. Paragraph 1.4, you explained that you were with the big 4 audit firms and that you were used to conducting audits with them. Yes?
Yes.
Now, while you were there, you would have done audits for groups of companies, of course.
Yes, sure.
And there it was important to distinguish between the individual companies within the group, wasn't it?
Yep.
And you had to be careful to attribute the liabilities and the assets of each individual company properly, yes? And there was a reason for that, because each of them has an independent legal personality, doesn't it?
Yes, indeed. Yeah, you're right.
And that's true even if one holds shares in another. It's a fundamental point, isn't it, Mr. Smith?
Yeah, it's basic.
Basic, elementary, yes. Page 10 of your report. Table 1 again. You've listed there short-term loans, the borrowings of the subsidiary. First line's from LearnFast UK, the sum of 780 we looked at before. Yes?
Yep.
And the third line is borrowing from Mr. Peters at $15,000.
Yes.
He's the main shareholder of the parent company, isn't he?
Yes.
And that debt is Mr. Peters' personal asset, isn't it?
Presumably, yeah.
It's not LearnFast UK's asset, is it?
No.
So it's wrong to count it as LearnFast UK's asset, isn't it?
Well, I wouldn't conclude this way, as you correctly stated before, Mr. Peters is the sole shareholder of LearnFast UK, and he was the only beneficiary of LearnFast UK. In this situation, being the sole shareholder and the only beneficiary, he invested money into Kaiton City project. He could invest, and in fact he did, in 2 ways. A certain amount of money, a certain amount of funds were invested through LearnFast UK, and some portion was invested through his direct transfer. So taking into account that he's the only shareholder, I believe it is reasonable and practical to consider both investments as part of one single investment into Kaiton City project.
If that were true, Mr. Smith, then the accountants and the auditors would have treated it as Kalia, the parent company's asset in the 2005 accounts, wouldn't it?
Yes, you're right.
Let's try the third one, if we've got time. I'm looking to the arbitrator for disapproval. I'm not getting too much of it, so I'm going to go for it. Third one, let's try and challenge an assumption. That what we want to establish here is it's unsafe to assume that LearnFast UK's, the parent company's auditors, verified that its loan to the subsidiary stood at £780,000 in 2005. So we can argue they haven't proven their case. This is a bit more of work because I've got to establish the fact pattern within which this assumption operates, but let's give it a go. Page 10 again, Table 1. Extract from 2005 accounts, and we've seen the $780,000 already. Yes?
Yes. Let's
focus on that. Now, paragraph 3.7 on the page, same page, you very properly point out that Kalia's accounts for 2005 were qualified by its auditors. Yes?
Yes.
And that qualification, as you explain, related to $500,000 worth of recorded borrowings, correct?
Correct, yes.
And you very fairly accept in that same paragraph that the $780,000, that $500,000 unproven qualified borrowing must form part of the $780,000 debt that Kalia owed to its parent, correct?
Correct.
But nevertheless, you say, and we're still here on page 10 at paragraph 3.9, that the parent company's 2,000 accounts are also contain the reference to the $780,000 loan to its subsidiary. Yes?
Yes,
And that they're not qualified.
exactly.
Yeah. And so you say that it's safe to conclude, so safe for us to assume that LearnFast UK, the parent, had lent $780,000 to its subsidiary by 2005, correct?
Correct. Yes.
That's your assumption there. All right. Let's go to your appendix 1. And you again very properly set out the qualification of the auditor itself. And we see that in fact the sum is in $515,000. And it's in fact not just for 2005, but for 2003, 4, and 5. The same qualification appears, correct?
Partial qualification.
Partial qualification, exactly. And then also very helpfully at the on that same page, you've set out a small section of the P&L for those 3 years of the subsidiary, and we can see the revenues. In the 2003, it was 880,000, and then rising to 1.5 million in 2004-5. So that $515,000 debt is somewhere between a half and a third of Kalia's turnover for those 3 years, correct?
Yes.
And so it's clear, isn't it, that the auditor considered that such a substantial debt to be material to the financial statements that he was auditing, correct?
Well, it could be. It is difficult to judge because every auditor decides by himself what materiality level should be considered in the course of the audit procedures. But it may be so.
Can I put it
Mr.
this
Samuel,
way?
we are going to have to wrap this up.
Yeah, this is the last. I'm very grateful. We can put it this way: if it weren't material, he wouldn't have checked it, would he?
Yes.
And he did check it, and he wasn't satisfied. Hence the qualification.
That's probably true.
What we don't know, and this is wrapping up, what we don't know from your report is the parent company's revenues, do we?
No.
We don't know the identity, the methodology of the auditor. Do we?
We don't know.
And we don't know whether he considered the $15,500 loan material, do we?
Yeah, that's true.
What we do know, page 4, is simply this. Paragraph 1.9, it was running 6 centres, 2 in England and 4 in Europe, which had been established for a long time, running international curricula at international prices, with revenues many more times than Kalia's singles local school.
That's true.
It's quite possible that the parent auditor didn't consider £515,000 debt material, so didn't check it.
It is possible, but I wouldn't be that sure to say that.
I'm very grateful, Mr. Arbitrator, for your indulgence.
Thank you, Mr. Samuel. I would like, of course, to turn to counsel for claimant, Ms. Richmond.
Thank you very much, Mr. Arbitrator. Like Richard and Vladimir before us, we will deal with 3 issues as well. In the interest of time, though, and given that Richard has now shown you how cross-examination can be done properly, Laura and I will take a bit of a different approach. We are going to mix both the good and the bad, and some might say the ugly, in one longer vignette. We're going to deal principally with 3 issues. The first is expert qualifications, background, and relationships. The second is limitations of the discounted cash flow or DCF method. And the third will be mixed throughout, and that deals with demeanor, tone, and related issues for both counsel and for the expert. So with that in mind, Ms. Hardin is now going to become Ms. Brown from the great state of Texas. Good morning, Ms. Brown.
Good morning.
I'm Lisa Richmond, and I work for the law firm Richmond, counsel for the claimant in this arbitration, Learn Fast UK Limited. I'll be asking you some questions on behalf of the claimant based upon the opinions you've expressed in the reports you've submitted as part of this arbitration.
Okay.
And Ms. Brown, I'd like to ask you a few questions about your background and your experience. You've provided your most recent CV as Appendix 1 to your second report, is that correct?
Yes, that's correct.
Ms. Brown, you are a managing director with BIG Numbers Forensic and Dispute Services, LLC out of Houston, Texas. Is that also correct?
Yes, that's correct. In the great state of Texas, as you said.
Ms. Brown, looking over your CV, can you tell me in approximately what percentage of matters you were engaged by the claimant and in what percentage of matters you were engaged by the respondent?
Well, just roughly give you kind of a rough percentage.
Yes, just a ballpark estimate, if you could, please.
Well, I would say, and this is just a rough estimate, that, approximately 100% of the cases I take are for the respondent.
Ms. Brown, to clarify, you've never acted as a party appointed expert on behalf of a claimant. Is that correct?
Yep, that's correct. I think that claimants have a tendency to be extremely greedy and grossly overstate their damages. Respondents tend to be much more realistic on the view of damages, in my opinion.
Interesting. So focusing again on your CV, could you review for the tribunal your experience in valuing education services, businesses, or franchises, please?
Yes. Well, I valued many service providers looking over my CV over the course of my career. These have included private performance improvement and accounting firms, wedding planners and music recording studios, all kinds of different service providers.
But none of these are educational services providers like Learn Fast UK Limited, are they?
Well, that's really irrelevant, honestly. I'm a valuation expert. I value all kinds of businesses, from oil and gas development fields to financial institutions and service industry providers, as I just said. I received my valuation qualifications and certifications, which allow me to value any type of business.
Ms. Brown, I wonder if you can answer my question instead of grandstanding like most Americans do. In none, literally not a single one of your engagements, have you acted as an expert relating to educational services providers like Learn Fast UK Limited. Isn't that true?
Well, actually, if you look at page 5 of my CV, you will see that there's a reference to a case that I worked on, an engagement for a professional coaching firm called Yes You Can Academy, which has outlets all over the greater Detroit, Michigan metropolitan area. I was working for the city of Detroit on that engagement.
Well, that's not exactly on point, is it? I mean, this is hardly on the scale of claimants' planned operations in the developing nation of the Republic of Kalia, now is it? In fact, you've never worked on any engagements involving developing nations, have you, Ms. Brown?
Have you been to Detroit recently, Ms. Richmond? I would argue that the similarities between Kalia and Detroit are quite significant. The government lacks resources and funding. There's a disparity in the standard of living.
You've got to be kidding, Ms. Brown. Is it your testimony that Detroit in the democratic United States and the Republic of Kalia are similar operating environments?
Well, they're actually not dissimilar. If you would allow me to finish my sentence, I think that some of the funding issues that come up with the Republic of Kalia are quite similar to the ones I experienced with the city of Detroit, in that the vendor had inexperience in dealing with this type of economically depressed environment in terms of what is reasonable to charge for services and what is affordable by the general public.
I wonder, Ms. Brown, if I could ask you to simply answer my original question. Isn't it true that in none of your engagements you have acted as an expert involving an educational service provider like Learn Fast UK Limited? Yes or no?
Not exactly, no.
Turning to your CV again, could you tell us how many times you've worked with respondent's counsel, Richard Samuel of Three Hair Court, or his instructing counsel from the law firm Lowball and Lynch?
Well, I don't know exactly how many times. I've worked with Mr. Samuel and the counsel of Lowball and Lynch a few times.
A few times? How many times is a few? More than 10 times? Could you try to give the tribunal an idea?
Well, over the course of my 25-year career, I certainly have worked with Mr. Samuel and Lowball and Lynch more than 10 times. Again, this is a relevant questioning. I've worked for a number of firms more than 10 times. I certainly have worked for example, Sue Grab It and Run 10 times at least, as well as Swindler, Backstabber, Bloodsucker, and Bob at least that many times. I do good work for my clients and they become repeat clients, and there's nothing unusual about that.
Well, let's focus on just 2019 and 2020 then. In the past 2 years, approximately what percentage of your revenue has come from working on matters for the firm that represents the respondent in this case, Lowball and Lynch? Again, just an estimate.
Well, just in the last 2 years, I would say 2/3 of my revenue has been coming from Lowball and Lynch. But if you asked me this in 2017 and 2018, it would be completely different, maybe 1/3 of the revenue during those years. It really varies considerably depending on who I'm working for in any given year.
Now, Ms. Brown, I'd like to ask you about previous work you've performed for the respondent, the Republic of Kalia. Have you acted for the Republic of Kalia on any other matters as a party appointed expert?
Well, for reasons of confidentiality, I'm not permitted to talk about my involvement in matters that I've worked on previously unless it becomes part of public record somehow.
But Ms. Brown, you're aware, are you not, that the IBA rules on the taking of evidence in international arbitration apply to this matter?
I suppose so.
And you're further aware, are you not, that Article 5 of the IBA rules on party-appointed experts explicitly state that your expert report should provide, open quote, a statement regarding your present and past relationship, if any, with any of the parties, their legal advisors, and the arbitral tribunal, closed quote. You're aware of this rule, are you not?
Well, I guess now that you put it that way, I am.
So I repeat my question. Have you acted for the respondent in this matter on any other matters as their party appointed expert?
Yes.
In what capacity and on how many occasions?
I have acted as the party appointed expert for the Republic of Kalia on 5 engagements, 5 other occasions on completely unrelated matters.
What types of matters were those?
They were oil and gas development projects. It had to do with alleged expropriation related to a imposed profits tax.
And are any of those matters presently ongoing?
3 of those matters are still ongoing.
So to confirm, you're currently working as a party appointed expert for the respondent in this case and on 3 other matters for a total of 4. Do I have that right?
Yes.
And could you please help the tribunal to understand why you failed to make this disclosure along with your report, notwithstanding your obligation to do so?
Well, I guess I just forgot.
Are there any other disclosures that you would like to make now to correct your prior failure to do so? That is, that you forgot to make?
Well, now that we're talking about it, I think there is another disclosure that I need to make. I previously worked for Glenn Hendricks, who is a partner of the law firm of our esteemed president of this tribunal, Mr. George Berman, at Hidden Good and Hart. I don't think that Mr. Berman is aware of this because the case began several years ago before he joined the firm, and it's been dormant for over a year as the party's been trying to settle.
Is this the only case with Hidden Good and Hart that you're involved in?
Yes.
Ms. Brown, I think we have time for just a few more questions
Yes,
before our lunch break.
Only a few moments.
Thank you very much, Mr. Arbitrator. We are indeed wrapping up. Please turn to page 27 of your expert your second report, the third paragraph from the top, table 7. Do you see that? This
Yes.
is where you provide a summary of your critiques of the claimant's discounted cash flow assumptions, correct?
Yes.
One of your critiques of the calculation performed by the claimant's expert, Mr. Smith, is that he relied on the feasibility study prepared by Mr. Peters, the claimant. Is that right?
That's correct.
And you further allege that in the feasibility study, Mr. Peters failed to allocate adequate costs for teachers to handle both the Circle 10 curriculum and more advanced classes. Is that also correct?
Yes, absolutely. This is one of the primary deficiencies that the claimant's damages claim. Clearly, the cost of the teacher's salary is a major input into the damages model, and Mr. Peters grossly understated that cost. There are really two reasons I think that it's understated. The first is—
Ms. Brown, I'm afraid I must ask you to confine your answers to yes or no, which is all I was asking for.
Okay, I'm sorry. I'm trying to answer your question to the best of my ability, and I'm afraid that not all questions can be answered with a simple or yes or no, because it would mischaracterize my opinions that I've expressed in my report. Mr. President, may I be allowed to elaborate on this question?
Yes, you may, within reason.
Okay, thank you very much, Mr. President. So to answer your question, Ms. Richmond, the cost for teachers' salaries and the claimant's damages model were clearly understated for two reasons. The first is that considerably more instructors would have been required in order to provide this split curriculum that would encompass both the basic required classes and meet the needs of local students at the same time. I estimate that would be at least double the number of that was planned in the feasibility study. Secondly, to combat the situation of extreme poverty that's being experienced in the Republic of Kalia, in 2000, the government instituted a mandatory requirement that all salaries be increased annually by 10%. This is not something that the claimant took into account in their feasibility study, and therefore it significantly overstates the claimant's damages.
I hope that brings you to the close of your questioning, Ms. Richmond.
May I ask one final question, Mr. Arbitrator?
Yes, one brief question with one brief answer.
Thank you. Ms. Hardin, the underlying assumptions that you've just detailed were based on the feasibility study on which both parties to this arbitration signed off. That is, that the Republic of Kalia participated in that feasibility study, the accuracy of which you are questioning now. Isn't that right?
That's true, but the final agreement between the parties specifically states the claimant will take into consideration any requirements of Circle 10 and acknowledges that these requirements may not be detailed specifically in the feasibility study included in Addendum 1. I don't recall the exact place it says it in the agreement, but certainly if you give me the agreement, I can show it to you.
Well, unfortunately, I think we're going to need to end there, but we can, of course, pick this up later. Thank you very much.
Thank you, counsel. Thank you. Now, unfortunately, we're going to have to bring this set of performances to an end. By my clock, we have less than a quarter of an hour, which is not what we anticipated. I had anticipated saying a fair amount, but I want to give our participants a chance to do so, not only to tell us why they proceeded the way they did in their examination, but how they would have done it differently if they would have done it differently. And of course, I'm going to give the experts a chance to comment on, among other things, how they were treated. Now, there are many, many things I'd like to say, so I'm going to be very, very concise. First of all, I did not intervene. Arbitrators do intervene, and there are many different styles of intervention during the examination. There are those arbitrators who don't allow counsel to finish a sentence. There are those who actually scribble down their questions on a napkin and hold them until after the examination has concluded. We don't have time to go into the merits or demerits of such methodologies. Let me just say then a few words, very few about substance, and of course, a fair amount about style. Now, on substance, I think we saw that counsel for respondent went quickly to the heart of things. He asked very, very precise questions that appeared to the tribunal, this is important, appeared to the tribunal to be pertinent, indeed highly pertinent. And among those would be, for example, I'll give you two examples. Was this the best evidence that was available for documenting the claim? If it wasn't the best evidence, why was the best evidence not adduced? That's obviously, in many circumstances, a promising avenue to go down. There was also an element of pointing out a contradiction. Contradictions are always to be pointed out. Contradictions in the report, and also contradictions, which we didn't have time to hear, with what that expert has said and written in other circumstances outside this particular case. Contradictions, I think, very, very important. I would love to say more about that. Turning, if you will, still on the matter of substance to Ms. Richmond, you know, in the interest of entertainment, it was awesome. It was awesome to observe the exchanges between you and Ms. Hardin. I think you would agree with me, though, if you had more time, you wouldn't have dwelt on so completely on Ms. Hardin's objectivity or lack thereof. I don't mean to diminish the importance of that. Speaking as an arbitrator, I would be influenced, quite honestly, by the extent to which the expert appeared to be, for lack of a better term, in the pocket of the party that had retained that expert. So, Ms. Richmond, I should say Lisa, they're entirely pertinent. And I appreciate that you dwelled on that aspect of Ms. Hardin's past professional life and present, rather than her credentials. You didn't, I don't believe, question her credentials. I will tell you, as an arbitrator, I think part of the function of this is to tell you how things play with an arbitrator, is that attacking the credentials of an expert is seldom fruitful. Seldom fruitful. An arbitrator might have the impression that that's all you have. And that does not go to the heart, obviously, of the testimony. On the other hand, if in fact Ms. Hardin has built her career around representing, I shouldn't say representing, testifying in support of a particular genre of actor in the marketplace, that does raise questions for the arbitrator. So I think Lisa pursued an avenue. I trust, Lisa, you would have gotten, had I allowed you to, much further into the substance of the expert report. And we just didn't have time for that. Now, it's already 8 past the hour. I want to say a word or two about demeanor and about style and tone. Now, of course, I don't think there is much to comment on with respect to the examination of Vladimir. The questioning was sober. Not that yours wasn't, Lisa. I'll get to that. The questioning was highly sober, cogent. The questions were closed rather than open, very easily followed by the arbitrator, who doesn't always get things. So making things simple enough, not simplistic, simple enough for the arbitrator is critical. And so I don't have any don'ts for Richard. It was a fact that Vladimir didn't have how shall I put it, didn't have the reservoir of answers that Laura had. So there was very little pushback. Now, why there was little pushback, Vladimir, you may tell us. That may be your style. On the other hand, it may be that there was nothing to push back. And you could not have pushed back with any credibility. I would love to hear about that, Vladimir. I think that's important. Now, with respect to our examination of Ms. Hardin, well, as you know, there were lots of don'ts in that performance. It was not the most don't-ful performance I have seen. Okay, I'm accustomed to seeing a great many more don'ts than that. I actually think, considering how hard you went, Lisa, you were highly respectful. And that's, I think, very important. You were respectful, you were tough, but you were respectful, and that's important, I think. You did interrupt as you intended to. You did interrupt the witness, which is not fatal, but not particularly desirable. But you were respectful. I would have intervened and said, please allow the witness to elaborate. The tribunal would be assisted. You wouldn't be surprised, Lisa, if that had happened.
Not at all.
Not at all. And ordinarily, I don't require the witness to ask I don't require the witness who may be unwilling to approach the arbitrator directly. I wouldn't wait for the witness to ask me whether she could continue in her response. So I would have intervened there. I just hope you know that. Actually, turning to the witness, and now I'm going to wrap it up. I thought you were a very skilled witness there. You were a little bit verbose. You did venture a little out of really the zone of what was necessary to answer the questions that were put to you. What you were not, and I'm glad to say this, what you were not, despite all your excesses, what you were not was what I often see, in my judgment, you were not defensive. I think you appropriately sought to justify some of the bizarre positions you took, such as the analogy between Detroit and Kalia. But a real no, a real don't, and I've been an expert witness many, many times on legal issues, avoid defensiveness. You didn't illustrate that, Laura, but I know you would agree with me. You sought not to be defensive, and you weren't. Now I have to stop there. Wow, we have 2 minutes. That leaves you, I don't know, 30 seconds each. So Laura, let's start with you. Any comments you'd like to make?
Yeah, actually, I was actually trying to be defensive. That was one of the things I was trying to do. So my acting skills apparently are not as good as I'd hoped.
No, I've just seen a lot worse.
But yeah, no, the idea is, honestly, if a person is, if the person cross-examining me is aggressive and interrupts me and those types of things, that makes me feel better, because it makes me feel like, as you said, they don't have very much to go on if they're going to be that way and try to control me. So, and I will not, I understand the closed question theory, and most experts can see where we're going with the closed questions. And I will answer closed questions, yes, no, yes, no, yes, no, for a little bit. But at some point, particularly if they're trying to make a point that I don't agree with, I'm not going to answer that. And that is a signpost, even if I'm not allowed to answer, for counsel to redirect me, and let me, not pontificate, but talk about why, that isn't correct, the conclusion.
Thank you, Laura. Yeah, I know you have more to tell us, but I want to turn to Vladimir.
No, I just want to say a couple of things. I mean, I entirely agree with Laura, and I mean, I was going to answer your question, George, why I didn't push back. I think the idea was to demonstrate how closed questions work. I mean, and what they make, how they will look like. However, in the meantime, I have to say that it's very critical to spend sufficient amount of time with your experts. I mean, and to get all the questions which can be put in place against the opposing party, so that the counsel then can structure them in the right way. And as Richard did it excellently when he was cross-examining me. So, but it was a preparation behind. So it's important to spend sufficient amount of time with your expert.
Thank you, thank you. Our speakers here are not having enough time to say everything they would like, and therefore I would like everybody to feel free to contact them individually. Lisa, would you share a few words with us as well?
Absolutely, George. Thank you so much. At 3 very brief points. As you correctly pointed out, and I just want to make clear to everyone, what Laura and I demonstrated was not intended to be this is what you should do. Absolutely not. It was intended purposefully to be a mix of good and bad. The second is that we wanted to spotlight the expert a little bit and to demonstrate how experts can go, even if you ask a closed question, beyond what it is that you've asked. Part of our hypo was based on the fact that in this matter, the respondent had the better of it with respect to damages. And so there, in that circumstance, one of the things that you would do is to really focus on their expertise and hear on the fact that they have worked solely for the respondent and get all of their revenue or the majority of it from there. And the final point is, had this been a real hearing, I might have considered intervening in Richard's questioning to object on the basis that he was unfairly representing the documents to which Vladimir had access, because the Republic of Kalia had taken all of those documents, such that it was unfair to suggest that Vladimir should have consulted certain things to which he did not have access and could not have had access because the Republic of Kalia refused to provide them.
Thank you, Lisa. I want to turn to Richard. Before I do that, I want to say, of course, we had no time for objections. There would have been plenty. Objections are not the favorite thing of tribunals. And when we have a tripartite tribunal, we often have to recess. We have to step into the corridor. It's not always a very edifying experience. Frivolous objections are to be avoided. And had you made objections, Lisa, they would not have been frivolous, I assume.
That's correct.
Okay, Richard, please, to wrap up.
I've said enough, but I'd agree with Vladimir about the importance of spending time with your expert before it happens. And I think the other important thing is, as George did here, is to trust the process, trust the cross-examiner, and not feel the urge to keep interrupting. You actually get a lot further in the process more quickly if they know what they're doing. So there we go. Those are my thoughts.
Well, thank you. Now we have run over. I wish we had more time. I don't think we're being allowed it. If I'm mistaken, I'd like to know immediately, but I'm going to assume we are not at liberty to exceed any further than we already have the time allowed. Obviously, I want to thank the performers for their performances. Really, they did their job. They did their job. I think you really got the highlights of cross-examination. A lot more to say, a lot more to see. But I must draw this episode, shall we call it, must draw this episode to a close. And of course, with gratitude to Glenn Hendricks for making all of this possible. Unless there are any further announcements from the organizers, I would like to remind you this is recorded, so you're free to see it again. All 4 of you are welcome to attempt to have it deleted if you feel it would impair your reputations. And with that, I bid you all adieu. Thank you.
Thank you.
Thank you.